Hi friends, I'm Sanjeev. I'm here to discuss with you the important, very crucial topic of Indian polity, that is High Court. Not usually, it's mentioned in Article 214 to Article 231, the organization, the appointment of judges of the High Court, as well as the structure of the High Court in those articles. Actually, in our integrated judicial system, High Court comes second after the Supreme Court, but above the subordinate courts. Its origination was initially started in 1862 when three high courts were set up in India. That is, that is Bombay High Court, Calcutta High Court, and Madras High Court. In 1866, the fourth one was established. That is Allahabad High Court. Actually, initially it was proposed that there would be a single high court for a single state, but in 7th Constitution Amendment Act, it was proposed that single high court can be established for one or more states. Another thing is that there is 7 union territory in India, but only Delhi is the union territory which have its own high court. Rest of the union territory usually jointly share the high court as per their location with other states, with other state high court. Let's discuss about the appointment of judges of the High Court. High Court judges are appointed by President in consultation with the Chief Justice of India as well as Governor of the state. If the appointment of Chief Justice of that particular state High Court is to be done. If there would be appointment of another judges, then Chief Justice of that particular state shall also be consulted. But in second judge's case, it is proposed that opinion of Chief Justice of India must be there for in the appointment of High Court judges. And in third judge's case in 1998, it was also proposed that two senior most judges shall be consulted with Chief Justice of India, or in other words, we can say the Chief Justice of India shall be consulted with two senior most judges of a single coliseum for giving the opinion on appointment of the high court judges. Second thing is appoint qualification of high court judges. There would be three qualification is given in our Indian constitution for the appointment of high court judges. One is that he shall be a citizen of India. Second is he shall hold any judicial office for 10 years or more in India, in the territory of India. And third one is that he must be, or he shall be a practicing advocate in any high court for 10 years or more. Actually, here it is remarkable that a distinguished jurist cannot be appointed as the judge of the high court, because distinguished, it is mentioned, it is agreed in when you see the article 124 about the constitution of the Supreme Court, about the appointment of judges in the Supreme Court, that there it is mentioned that a person who is distinguished jurist can be appointed as a judge of Supreme Court, but here distinguished jurist cannot be appointed as judge of High Court. Third one is that oath and affirmation. Oath is usually given, though High Court judges are appointed by President, but oath will be given to them by governor of that particular state. Third one is that there would be the removal. Removal, it is mentioned there that removal is not very easy. Removal is can be only done on the ground of two, that is, one is misbehavior, second is incapacity. The two grounds are mentioned, but actually it is not explicitly described there. uh, second thing is that the procedure, the Regulation Act, the Justice Regulation Act, it is mentioned that the procedure shall be very simple. That is very simple, but actually its passing is very tough in the Parliament, because actually the 50 when any Rajya Sabha member 50 Rajya Sabha member shall be proposed, or 100 Lok Sabha members shall be proposed, the removal of the High Court judges, and it should be accepted. It must be accepted by the Speaker, or the Chairman of Lok Sabha, Rajya Sabha respectively. And actually it is It is depend on the volition of the chairman or the speaker whether he or she will admit this, the removal procedure or not. If he or she will admit, then ultimately the second thing is going on. There would be the provision of establishment of a committee who you know the who usually investigate the procedure, the about the allegation, whatever the allegation which is imposed on the ground, on the judge, or on the ground. They usually, the verify the details, whether he is responsible or not, or he must be removed or not. After that, when they usually, the committee, which is established by the chairman or speaker, usually give their opinion, give their report, then ultimately the resolution must be passed by two-third of majority in each house respectively, in Rajya Sabha and Lok Sabha. Then and the judges, and then the report will be sent to the president, and ultimately the judge will be removed. But actually, it is very surprising fact that till now, no any judge is removed through this procedure. So actually, this is the about the removal procedure, and rest of the topic we will discuss with you. Thank you.